talking about the development of data protection legislation in India. The Supreme Court of India has established its right to privacy and data protection as a fundamental right in Justice case Puttaswamy retired versus Union of India 2017, and the present legislative framework for privacy outlined in the IT Rules 2011, which governs the collecting, receiving, possessing, storing, dealing, handling, retaining, and transferring, disclosing, personal information, security procedures, and handling the personal information. It was insufficient at 4 levels. First, the existing model assumed that privacy is a statutory right rather than a fundamental one. Second, it understood only a few data types that can be shielded. Third, it imposed very few responsibilities on data controllers. Fourth was with regards to the punishment. Now, what is Personal Data Protection Bill 2018? Justice Sri Krishna Committee tasked the Ministry of Electronics and Information to draft this bill. The new provision on the data localization which was generated that created good compliance. This brings upon the bill's second issue. It permits the processing of the personal data in the interest of state security permitted in accordance with the legal procedure. Last but not least, the draft law established a regulatory framework that was independent enough, and it was heavily under the influence of the central government. Now, Personal Data Protection Bill 2019, which was later withdrawn amid promises of a replacement measure that would adhere to the modifications. Data Protection Bill 21 was a single law put out by the committee that would cover both personal and non-personal data sets, as it develops the framework of the cross-border transfer, accountability of entities processing data, and potential remedies for unauthorized harmful processing. Digital Personal Data Protection Bill 2022. Now, every digital processing private information is now subject to this bill. This would cover both personally identifiable information gathered online and offline that has been converted to digital form by way of handling. Now, comparison of these bills. The territorial implementation of the bill also addresses handling of the personal data. Fine, which was released to up to 500 crore, and the previous law was limiting to 250 crores. Rights. Right to be forgotten. Right to access data, and consent being the most important asset.